All right, this is going to be a full breakdown as the actual judgment, amended judgment by the court in crypto Open Patent Alliance versus Craig Wright, BTC core developers. Break this thing down. It's about 41 pages. I'm just finally done reviewing it all and literally doing an analysis on it from a non-lawyer's perspective. But I think it's going to be pretty insightful because I got the whole thing broken down as to what really it actually means and what's going to happen. So looks like a judgment was issued on the 20th of December, and they've made some scheduling orders, case management, and then discovery orders. All right, so the case management is going to be pushing the trial out, a few weeks into February, and it's going to extend out from there. The discovery orders are going to be about what's going to be admissible and what isn't. All right, so let's break this bad boy down. I'm going to show you how this thing works right now. So check this out. This actually stems from this letter in 2022 from OnTier to the Bitcoin developers before the lawsuit was filed. This is the preliminary letter that went out on Wright's attorneys, also known as Satoshi Nakamoto, sent this out to a list of developers. And it asserts that the Bitcoin protocol and database were copied by them and other developers to create a new network called BTC. And the database used on that network is owned by Wright and this trust, this limited company. So in the letter is asking them to comply with their fiduciary duties, act in good faith, not make profit out of your trust, not make yourself in a position where your duty owed to, let's say, Wright, and your interest may be in conflict, and not act for your own benefit or the benefit of a third party without the informed consent of Wright. You should, and what they were asking for in this preliminary letter prior to this whole thing happening, this whole lawsuit happening, is should you implement the rules required for the recovery of Bitcoin as per the white paper. In particular, Wright contends that the white paper specifically says rules should be enforced using certain mechanisms that allow for this. You should comply with your fiduciary duty as agents of the Bitcoin BTC network, and you should not fight. You should not fight and cease fighting against claims for recovery of Bitcoin brought against you by Tulip Trading Trust, and follow the original protocol specifications designed by Dr. Wright, and not make attempts to change the protocol further. And you should implement further controls designed to implement further controls designed to enable anti-money laundering provisions. You should not misrepresent that BTC network has thousands of nodes, but you should refer to the nodes as defined in the white paper. Should you not do these things, then you forfeit your access to the software repository on which the BTC software is held. BTC, that's the forked chain or the provision that's acting under the name Bitcoin. All of your rights as developers of the BTC network and other network based upon the original Bitcoin protocol must be rescinded. You must return to Wright all software relating to the BTC network. So that, of course, didn't happen. And then the litigation, it started. So now let's go over here. All right, this is the High Court Business and Intellectual Property as of December 20th. So this is 2 days ago. December 20th, 2023. And this is the 41-page judgment, approved judgment for what's going to happen. Now, I'm going to give this to you, break it down just by what was said. I'm not going to add my opinion and a bunch of nonsense about like who's going to win and all that. We don't know yet. All right. None of that's sense. So really not relevant. Let's just see what the courts decided. Okay. And keep all the conjecture out. So here we go. Let's take a look. All right, so this is a pretrial judgment and a hearing to decide various issues on the upcoming joint trial to determine whether Craig Wright is Satoshi Nakamoto. All right, so the main issues that were presented here were Dr. Wright's applications to rely on additional documents. Additional documents. This is the main thing that was decided that's relevant. The additional documents consisted of 97 documents called latex files and other documents that Dr. Wright argued that were critical to his case. Now, the Copa developers opposed the reliance that the additional documents produced evidence, and the Copa believes that they're forged and fabricated. However, the judge ruled that it would not be right to make a finding. So the judge said that they would not make any pre-trial determination on this additional evidence. Some of the interesting points here that were pointed out, I'm going to show you in the highlights here, but in summary, the judge gave Dr. Wright permission to rely on these additional documents at the trial and made no determination as to what they mean or what effect they're going to have. All that's been decided is that they are going to be allowed to be reviewed and considered at the trial. So one of the things that's very unique here is, so this is paragraph 38, Ms. Field's contention on an 18-page document, which she submitted to the court. She contends, now Ms. Field is Wright's lead counsel here, writing this argument here to the court. As Ms. Field says, if that's correct, now this is about these new additional documents, right? So if they're correct, then the 95 documents are at least very strong evidence that Dr. Wright is Satoshi Nakamoto, as is clear from the nature and the context. Ms. Field has set out of Schedule 1 in her statement and the explanation of the relevance of these documents based on information provided by Dr. Wright, which proceeds on that basis that the documents in the BDO image were not modified since 2007. Now, she makes one qualification stating that the latex documents in respect of Ms. Field's statements have two key pieces of evidence in Dr. Wright, from Dr. Wright. In summary, the relevance of the latex files are so unique that such a mere possession of them is evidence of authorship of the white paper. This is her contention. And it's practically infeasible to reverse engineer latex code from the Bitcoin white paper. These are the contentions by Ms. Field. She also contends that the white paper latex files are therefore the highest possible importance for the identity of the issue, which is the identity of Satoshi Nakamoto. And these issues cannot be determined unless Dr. Wright is enabled to rely on these documents. So she's arguing to say this has to be brought in. Now, Copa responds and they say that these are all forged, they're irrelevant, and they're going to be harmed and prejudiced by bringing in these documents and their evidence of forgery. This is what's to be determined, right? So that's their allegations. They say these documents are forged. And the court says, okay, well, we understand that the Copa believes they're forged, but that's going to have to be determined at trial. And so that's what these, basically is going to be going on. So there's some really interesting points. Yeah, one of the things that's interesting here is the court's making this order stating that he would like some clarification. He would like Copa and Dr. Wright to consider whether there are such practical limitations which can be imposed on each side so that enable the trial to proceed on the existing trial listing. More specifically, Copa should consider which of their currently pled 50 allegations of forgery may be repetitions and nominate their principal allegations. So Copa's got, they're throwing every single thing possible. They got 50 allegations of forgery of all this stuff. And the court's like, okay, which of this is most important? Because we got so much stuff you're throwing over here that it's hard for the court to even just determine. It wants to kind of have a focus as to what's going to be relevant, what's their key focus of forgery. They've got a lot of allegations. So there's a bunch of back and forth here about bringing in these documents and how they're confidential. Wright, Ms. Field says that they're all confidential, and Wright believes they're confidential and they shouldn't be just put out there on the internet. And so the court's determining here that they're going to go to Mr. Madden, who apparently must be some sort of a neutral party, to hold in trust the documents for him to make a determination on whether or not some of the stuff is relevant or not. So apparently that's where they're going to be, and nobody's going to be able to see the contents of those files. Some of the files anyways. Let's go down. Most of the back and forth here is like about the other Copa saying that, Copa wants the court to make a determination that that all these documents are irrelevant and strike them right now so they don't come in. And then Wright's counsel is arguing heavily that these are going to be required to be issued at trial, and not to make a pretrial determination on these additional documents. What's interesting, though, is it says that in regarding to the counsel, Dr. Wright warned me against conducting any sort of mini trial and submitted that the courts have repeatedly emphasized the need for a particular caution before summarily determination on paper allegations of serious wrongdoing. And then the court sets out that I'm not going to engage in any sort of mini trial. I propose to abide by the warnings and those authorities. All right, so that's what the court's saying. I'm not going to look at these and make any predeterminations at all. All right, so that's been determined that nothing's going to be determined on this new evidence other than whether or not it's going to be looked at or not. That's what's been determined. So it continues on. The short points is that if the additional documents are authentic, they are likely determinative of the issue in Dr. Wright's favor. So this is 72, in view of the emphasis placed on the importance of the latex files on this application, it is moderately surprising to say that at the least Dr. Wright did not seek to rely on these files months ago. So this is interesting because he's now introduced what his counsel Ms. Field, saying is the most important piece of evidence so far. That seems to be what her claim is that this is like the most valuable determination piece of evidence for the identity issue so far, and it hasn't been brought up till now. So it seems like Wright was holding this back. His failure to do so cannot be blamed on the supposedly bad legal advice from his past attorneys. Wright's saying he got bad legal advice and he fired these other attorneys. Dr. Wright must have been aware of it, as he is now, and that the unique nature of these latex files and the fact that the case and the Bitcoin wiper was originally written in latex. So I cannot decide any of these issues right now if there's back and forth on, bad legal advice and why these weren't introduced further. Okay. So, but the court's saying I can't decide any of that stuff right now. If they're going to be ventilated, then it must take place at trial. All that stuff's going to have to be argued at trial, and the court's not going to even consider any back and forth. So now Copa is saying that there's strong evidence that the BDO drive and the material allegations it contains have been manipulated. That's what Copa says. They're claiming it's manipulated and forged. Overall, I am left in no doubt that Dr. Wright should have permission to rely on some or all of these additional documents on certain conditions. All right, so Miss Field, it apparently is the one that is, really deserves the credit for convincing this court to now bring in this additional evidence. So let's take a look here. So check it out. Hannah Field, Shoosmiths, dispute resolution, intellectual property, real estate, business, crime, compliance, tax, and she's in London. She's a partner with a dispute resolution and litigation team at Shoosmiths in a corporate commercial litigation team with over 20 years of experience. So she's the one that they're calling to Miss Field, who is now getting the credit for allowing what's called the latex files to be introduced. Now, apparently on her arguments and assertions that those files, now that they're going to be heard, those files are going to be looked at. That's what's been determined. That's the big news. The scheduling issue is really not that big of a deal. It's the trial's going to be delayed till February. Okay, fine. The court basically, this is a new attorney, and so they're saying we didn't have enough time to prepare. We needed an extension of time to prepare for trial. So that's going to be, or it's not that big of a deal. What's big is that this new evidence, which was never looked at before or even revealed before about these latex files, which apparently are how the white paper was written in. It was some sort of a forensic file that how the white paper was written. She was successful at arguing that the court must consider this new evidence. The court had some back and forth kind of saying, well, why the heck wasn't this brought in before? This should have been brought up a long time ago. Why are you guys waiting so long? And then Wright stating, well, I got bad legal advice from the attorneys who I fired. they told me not to bring that in, and I fired them. And so now they're coming in, and this new attorney, Miss Field of Shoosmith, is bringing it all in, and it's been awarded to be considered. So like the motion to strike or whatever objections the Copa and the BTC Core attorneys had are all denied, and this is going to be heard. So there were some other issues that were determined about, they were mostly just about like scheduling, and then costs, about who gets costs here and there. Those aren't really didn't really seem to be that big of a deal. There was one more paragraph in this order which is relatively significant. All right, so for paragraph 80, there's actually more than one. So it's 85, where Ms. Field is putting forward a witness statement about her evaluation of the white paper and the latex files, and stating that the Bitcoin white paper published by Satoshi Nakamoto. So this explanation appears to be founded on the allegedly unique nature of the latex code, and that it was practically infeasible to reverse engineer that code. And accordingly, the court directed that the overleaf latex files were to be disclosed to Copa on the basis of the confidentiality terms as set out in the patents court guide. So at this point, we don't know what was in those files. I see some other stuff on the internet saying, oh, this is what the files look like. Unless this guy Madden released them on the internet, that we don't know what they say. And I doubt that happened, because it would be against the law for someone to just release these files out when the courts ordered them to be, sealed and confidential. So we don't really know what they say, but apparently, according to Ms. Field, they're very, very strong in proving that it's going to be hard to say that Wright's not Satoshi. Now there's one more paragraph down here at the end. I think it's one. Yeah. So it looks like, it's true. Okay. So cost, this is about the cost side. So it's just whether or not, who's going to be paying additional costs for the back and forth in litigation. It's not really determining facts, but it is interesting what the court says here. It says it is true that the Copa developers made substantial submissions, both in writing and orally, that they sought to persuade me to exclude additional documents, and in that endeavor, they failed. However, the materials on which those arguments were based formed essential information on the further steps necessary to get this case to trial. All right, so that's the main, ultimately kind of a summary on the main thing that's going on here is these new documents are going to be looked at by the court and considered. All right, so looks like we're still recording. Okay, so that's the main thing, dude. That lady, Miss Field, man, it'd be great to talk with her. She looks like a really, classy solicitor. They call him a solicitor from a non-lawyer's perspective. I wish I had her. I'd be able to talk to her and ask her questions. But it probably cost a large retainer for something like that. I don't know how much they're being paid. So, but that's the main thing. Now it would be interesting. There's definitely, I got a challenge out there. I want to do a interview with somebody on Bitcoin, people who are, even if you're knowledgeable, I don't care if you're already knowledgeable on Bitcoin or if you're just new about it. This case is a big deal. And I want to talk to somebody about who wants to learn more, and then just do a recording like this and get it out there on the internet, because there's a lot of insight that I have on this that could really, be good to share, and in my perspective on how I've been following this. And I just want to do it in an interview. So my perspective is I'll send somebody the original Bitcoin, Satoshi Vision, one of those, just for doing an interview, a podcast with me. So if you're interested in that, mention me on Twitter, and then I will just, follow me so I can message you directly, and mention me on Twitter. And then I'll just reach out to someone and do like a Zoom video. And then I'll send them one Bitcoin Satoshi Vision. If you haven't already gotten your first, I'll tell you, after the interview, I'll just go ahead and show you how to set up a wallet, and I'll send that to you. And everybody, whether you're on Team BTC or Team Copa or Team Wright, whichever team you're on, everybody should have one Bitcoin Satoshi Vision. One. It's affordable. It's less than $50, $47. Everybody should have just one. I'm not saying don't load up and invest money. Don't do that. That's nuts. But it would be really smart, everyone who sees this, to have at least one. All right, dude. I think just because of the potential as to what could happen. Now, if it goes to zero, well, you lost $47, right? But if the BTC, you buy one BTC, what is that? 40,000? Now that's pretty substantial. That goes to zero, you lost a lot, because that's what's at stake. BSV is not at stake of going to zero on this lawsuit. Not at all. That's not potentially what happened. But what could happen is if like, as you read in that initial letter, is if the court decides that Craig Satoshi and that these guys are using the BTC software, the developers, with that's not in compliance with what the copyright holder had determined, they could actually determine that, hey, you guys need to bring that software back and order them to bring it back and stop using that chain. I mean, the ramifications of this are pretty massive. So yes, anybody who's promoting BTC, which is just it's a masquerading as Bitcoin. I mean, if you look at it, it has nothing to do with Bitcoin. It's just it's something that's been technology wise, it's just created something else completely, calling itself, using the name Bitcoin, but it's nothing to do with what was in the white paper. Okay. When you really do an analysis. So and I'm not, just, that's my perspective of how I'm seeing it. So the point is, if anybody who's promoting that right now, BTC to the moon, like Michael Saylor and these guys who are doing videos about it, a lot of other people, it would be smart of them to put a disclaimer saying, oh, by the way, there's a case going on that everything I'm saying here, this whole thing can this whole thing can stop. Now, if they stop mining the BTC, it just goes away. There's no value to it. It will stop mining. I don't know if that's even possibly technical. Maybe that's a long-term thing, but that could be an outcome of this case. I mean, it's that significant. Will it happen? I don't know. But people should have a disclaimer on that. If they're going to be promoting people to invest in BTC, because it's pretty, it could have some serious ramifications. That being said, dude, Bitcoin BSV is, you could send Bitcoin Satoshi Vision, the hand cash link below if you want to make more videos like this. And definitely, if you want to do like a podcast like this with me, reach out to me on Twitter and a mention at Gavin Mail on Twitter. And I'll reach out to somebody. We'll do a freaking interview like this, and I'll send you one Bitcoin Satoshi Vision for that. So this is a summary of this recent judgment, cut through all the noise and the conjecture, and just give you an honest perspective as to what the court's actually determined. And way to go, Miss Fields, for the Craig Wright team. Anybody who's in the Craig Wright's team side, man, she did a really good job. It looks like, I mean, in bringing forward and getting this evidence to be determined. So right before Christmas, that's a big deal on all this new evidence. So we'll see who the witnesses are going to be and how it's all going to go down. Looks like it's going to be February for the trial. This is Gavin Mail. Like, comment, and subscribe, baby. We'll see you at the top.